večer, dragi forumaši. Good evening, all members of the forum, our interested audience. It's my pleasure to announce our guest for tonight, Professor Alexander Vylegzhanin from the Moscow State University of International Relations. He is the head of the Department of International Law there, and he is a great friend of our faculty. It's his third visit already. And yesterday we have had a very interesting and successful conference regarding space law, regarding the exploitation of natural resources in space, so very, very contemporary subjects not related to legal history. While tonight he will hold a lecture regarding something from the past ages, a history of the law of the sea. While it is my pleasure to introduce him to you, it's my pity that I have to introduce him in English and not in Russian. I am sorry that we can't have a lecture in Russian, but I'm afraid that our audience would be somewhat smaller if we did. And of course, Professor Vylegzhanin speaks perfect English, so we won't be having any problems in that regard. And naturally, as always, if someone afterwards wants to ask a question and isn't certain in their English or Russian, feel free to ask in Serbian and I'll help translate and so on. I convey the apologies of our forum Caesar, Professor Sima Abramovic, who is unable to be with us this time, either online or offline, because he has some obligations tonight, but I'm sure he'll watch the recording afterwards. So, Professor Vylegzhanin, welcome. I'll share your presentation and leave the floor to you.
Thank you so much for this nice introduction. I'm really a friend of the law faculty of your university, and indeed the international conference which was organized yesterday by your university was really a success. Today, from the outer space, we come to the world ocean, to the sea, to the history of the law of the sea. And I think for any lawyer, it's good to know something more about the history of the law of the sea than it is written in the textbooks, in your textbooks, in the textbooks of our university. So I hope I may sit. Yes, thank you. And I understand that I might do it like this. Yes, good, excellent. Yes. So as you could see from the screen, we'll speak about some sketches of the history of the law of the sea, and I hope that Okay, good, thanks. And I hope that at any time when you wish to ask something, please do not hesitate to raise your hands and we can discuss. For instance, oh, Professor, that is not so. I think that the Roman law was not so significant for the law of the sea or something. My students do this during our master's degree courses. And I think that when we speak about the history, of course, there are different options, different interpretations of this fact or that particular legal act. And that is quite understandable because competition in legal interpretation of international law documents, of national law documents, is a reality. For instance, yesterday we spoke about some outer space innovations, and again we can say that there are different interpretations of the relevant international law documents. The same in the law of the sea. If you look through the numerous textbooks on the law of the sea, in your library or in the library of our university, I might say that they usually devote very, I would say, the bulk of the textbook is devoted to the current law of the sea, to the legal acts which form the basis of international law of the sea today. As for the history of the law of the sea, sometimes there is no pages at all, no specific, I would say, paragraph or chapter devoted to the history of the law of the sea. But some, of course, have something. So another bulk of such books, both in Russian, both in English, and I might say that what is important is that historical review creates an awareness of the international political milieu in which the maritime activities of states are regulated by modern law of the sea. So it's a sort of additional legal aspects. It's a sort of additional legal information, legal and historical, which might help you in your future legal work. As I say, when we say about modern law of the sea, we usually say about UN Convention on the Law of the Sea of 1982, and everybody practically knows about it, but I'm sorry. Thank you. Thank you. And when we say about the modern law of the sea, of course it's not a topic of this lecture, but in any case, we are supposed to know what is usually in the textbook on the law of the sea. I don't know where. Doesn't function. Here. I see. In the textbooks on the law of the sea, the traditional sketches are on your screen now. So these are the Hague Conference of 1930. The conference was devoted to codification of international law in general, not specifically on the law of the sea. But during this conference, the questions were discussed widely about the breadth of the territorial sea. Some countries suggest that the territorial sea might be 3 miles. Some suggest 4 miles, 6 miles, and so on. And I hope that everybody understands what is territorial sea. If not, I just tell you that territorial sea is an area of the sea which is, so to say, near the land area of a state, of any coastal state. Coastal zone, that's a new area which was suggested because the territorial sea is a sort of maritime territory of a state. In territorial sea, a coastal state has sovereignty. So it's the same as a part of land territory. The only difference is the innocent passage, the right of innocent passage, that is, a foreign state, a foreign sovereign, might, without consent of the coastal state, send its warship or cargo ship or whatever, merchant vessel, through the territorial sea. and that is called innocent passage. So the questions, what might be this territorial sea, was a sort of, I would say, hot issue during the Hague Conference of 1930. No decision was taken. Now, the history of the first, second, and third UN conferences on the law of the sea. The first conference, which took place in 1958, was really very, very prolific. 4 conventions, 4 first UN conventions on the law of the sea were adopted. The first convention was on the high seas, the second on the territorial sea and the contiguous zone, the third convention on the continental shelf, and the fourth, about conservation of the living resources of the high seas. And the only difficult issue was, again, what might be the breadth of the territorial sea. Again, the same question which was discussed at the Hague Conference of 1930. And again, there was no decision on this issue, because again, some states insisted on 3 miles limit. 1 mile, it's 1,852 nautical mile. So, meters. So, you see, when we say nautical mile, it might differ from a mile on land territory. But in any case, no limit was adopted universally. Neither 3 miles limit of the territorial sea, nor 6 miles limit on the territorial sea, or 12 miles limit, which was also suggested. But the success of this conference, the conference of 1958, the success of this conference, that for the first time in the history of humankind, the specific conventions on the law of the sea were adopted. And that was a sort of order on the world ocean. And of course, when we say about legal order, it's a positive trend, surely. The second conference in 1960, it is not on screen, this conference was another attempt to somehow agree upon between states what might be the breadth of the territorial sea. Of course, you might ask questions, well, Professor, 2 conferences, so money is spent, delegations are discussing their problem, their positions, they exchange opinions, and devoted only to one specific issue, the breadth of the territorial sea. This is really a very important issue, because for any coastal state, of course, it's very important to have specific limit of its territorial sea. Within the territorial sea, the coastal states has full sovereignty, with the exception of innocent passage. For the world community, for those countries who have developed fleet, especially navy fleet, they were interested in less breadth of the territorial sea. You understand that means that the more space is provided for the high seas. And on the high seas, you have different freedoms. Freedom of fishing, freedom of navigation, freedom of scientific research, etc., etc. So the debate between the states which were interested in narrow breadth of the territorial sea, in the narrow territorial sea, and those who favor large breadth, big breadth, long breadth of the territorial sea. This debate was really very, very important. These reflect sensitive issues of state security and of the interests of world trade and world navigation. The compromise was reached only during the third conference on the law of the sea, that took place beginning from preparatory committee, that is from 1967, and the conference itself, again, the third UN conference on the law of the sea from 1973, and ended this conference, as you understand, only with the adoption of the UN Convention on the Law of the Sea, UNCLOS sometimes it is called, of 1982. So this compromise, what is the breadth of the territorial sea, was at last reached. 12 nautical miles. 12 nautical miles. This is the breadth of the territorial sea, which was established by the UN Convention on the Law of the Sea. UN Convention on the Law of the Sea. And again, in order to reach such an agreement, the work of the International Law Commission was really very, very important. It is the International Law Commission, probably you have known, you have heard something about this organ. It was established after the World War II, and the International Law Commission is a principal international legal agency which is responsible for codification of international law generally, not only on this branch of international law as the law of the sea. So when we say about all this modern history of international law of the sea, we concentrate on the current state of the law of the sea. But what about before? What was before? And I think that sometimes even good lawyers who work in the maritime industry, sometimes they have heard something about, say, battle of ideas between Hugo Grotius or John Selden, which was a long, long time ago. Yes, they have heard something. They know that Hugo Grotius was for mare liberum in Latin, that is open sea, openness, freedom of the high seas, the principle which was established later on in the UN Conventions on the Law of the Sea of 1958. We were talking about it. And his opponent from Great Britain, Hugo Grotius was from Holland, and his opponent, John Selden, was from Great Britain, who favored mare clausum, that is, closed sea. According to his opinion, Great Britain, as the first, number one, at that period of time, navy country, of course, it has its own rights to establish sovereignty on huge spaces of the world ocean. What about the Middle Ages? The key question is whether during the Middle Ages the legal order in the world ocean already existed or not. Let us pay attention to some sources, some documents which we have today and which influenced greatly the modern law of the sea, the formation of the modern law of the sea. And the Rhodian laws on the screen before you, the Code of Maritime laws adopted by the people of the island of Rhodes approximately between 600 and 800 before Christmas. The essence of the Rhodian laws reflect peculiarities of Rhodian trade and relevant aspects of life. Rhodes was a center of entrepreneurship in the field of trade via seas. For this reason, the rules of Rhodes law regarding carriage by sea and other issues had a significant influence on the Roman law. I would draw your attention to the correspondence between the Russian Tsar, Ivan the Terrible, and the King of Great Britain, and the King of Great Britain asked the Russian Tsar to close one of its seas so that no foreign merchant vessels enter the Russian sea. And the Russian Tsar answered, as you could see, Божию дорогу, океан, море, как можно унять, перенять или затворить? That is, it is impossible to occupy or enclose the God's road, the oceans and seas. It was in the 15th century. So you could see that the idea that the world ocean is free for anybody who would like to navigate was not in the letters or in the scientific book of Grotzos first expressed. It was expressed in the diplomatic correspondence between these two monarchs, between these two sovereigns. And it is interesting that this fact is sort of popularized, is reflected in numerous textbooks in Russia, but I couldn't find any textbook on the law of the sea in Great Britain, in France, in the United States, where this fact was reflected. Interesting enough, that is also competition for the priority of scientific ideas. Now, about Basilica. The last codification of the Byzantine law was completed in 890 under the Emperor Leo VI, Leo the Wise. Basilica consists of 60 books based on the legislation of Emperor Justinian. Of course, you know about Justinian's codifications. It reflects many provisions from the Rhodian laws. The principles and norms of the positive law incorporated in Basilica were sanctioned by the state, by the emperor, and emperor reflects the will of the state. And international law, it's a sort of compromise between sovereign states. International law is created by agreement between sovereign states. That is the difference between international law and national law. National law, of course, it's also a reality. You cannot find any state, any coastal state today, which has not adopted maritime legislation. Of course, if it is a coastal state, it is obligatory to adopt a maritime legislation. Otherwise, it is not so clear how other foreign states might enter its ports, whether there are some limitations regarding the environmental control, and so on and so forth. So both maritime national laws and international law of the sea, these areas of regulation coexist, so to say. Again, I would like to draw your attention that the Byzantine law, in Russian it's Byzantine право, Byzantine law were sanctioned by states. They regulated, first and foremost, the relations stemming from the maritime trade and navigation in the Mediterranean and Black Seas. So we can say that it is these areas, Mediterranean and Black Seas, were probably the first objects of international law of the sea. Though there are other concepts which rely upon different facts, and probably today we do not know exactly where the first maritime laws were adopted. What we have now in this lecture, we draw attention to the most notorious legal sources. And Assizes of Jerusalem, Yerusalimsky Assize, the code of laws of the Kingdom of Jerusalem. This code was applied in the Kingdom of Cyprus and in some other states created by the Crusaders in the Middle East. The norms of maritime law contained in the Assizes of Jerusalem were influenced mainly by customs that developed in the Eastern Mediterranean. And here I have to be sure that you understand me, that you follow me, to make a remark what the custom means for international law. International law has different sources. Among the major sources of international law, as is provided in the Charter of the United Nations, are international treaties or international agreements, it's the same, international custom, and general principles of law, which were developed during the history of interrelations between states. So international custom is really a major source of international law, and in contrast to international treaty, sometimes the content of this or that international custom is not so clear. When you take international treaty, international agreement, you can read it. Everything is, so to say, clear. If it is not clear, that was the will of the two states. But what is agreed upon is obvious from the text of international agreement. And international custom does not have the same characteristic. International custom, it's a sort of general practice of states, but not only practice, but also completed with the so-called opinio iuris, Latin word, which means that states are aware that such practice is a legal necessity, So when we say about custom, of course we mean the legal source, which was, of course, during the early years of the history of international law, was the major source of international law. Some people say that even now international law, in some branches of international law, still is more significant than international treaties. For instance, in the outer space law, which we discussed in your university yesterday, of course, international treaties are the major source. But in the law of the sea, according to International Court of Justice, it's international custom which plays the major role. The observance of the rules contained in the assizes of Jerusalem is a reality. In fact, the rules were applicable to disputes related to maritime trade and navigation. The proceedings based on these rules were carried out by maritime magistrates, a sort of legal organs, courts, so to say, and also consuls appointed to the trading ports. For this trading port, this consul; for that, another consul. But sometimes a consul might be appointed for different trades. You could see the names of these ports: Marseille, Vienna, Venice, etc., etc. Once again, I want to say that, of course, it's an early history of the law of the sea, but these sources are really cited in the modern legal teachings of the law of the sea. And, of course, if you might work in the marine industry or in companies, in the ministries, and if, for instance, you have not heard about the code of laws on the Kingdom of Jerusalem, that means, of course, there is something some lacuna in your legal education. So, of course, I advise to have some general knowledge about these legal sources. And also the rules of Oleron. These also is a systematized code of maritime regulations that became widespread in the ports of the Atlantic coast of France in connection with the development of maritime trade with the Mediterranean countries again Mediterranean Sea. The rules of Oleron were a collection of decisions taken by the maritime courts in the island of Oleron near Bordeaux. Bordeaux, I'm sure you know where it is situated in France. And in the 12th century, these Oleron, island of Oleron, became an important trading center. The maritime regulations contained in the rule of Oleron were confirmed by a royal ordinance in 19th century. The rules were also adopted by the order of Richard I, and they were translated into English from French, as you understand. Admiralty Court in England recognized this source as having the force of an edict of the English king. And the papal book in the city of Bruges, published in the 19th century, was considered to be the English authentic translation of this, the rules of Oleron. The rules of Oleron influenced the development of the laws of Visby that were enforced in the cities of Hanseatic League, and the influence of the rules of Oleron spread to the Mediterranean through Spain and the southern parts in France. So the Rôle d'Oléron, as French, I'm very proud of French lawyers, my friends, are really very proud that not only Great Britain contributed to the early sources of the law of the sea, but also France, and France is, of course, also pretends to be a huge maritime or great maritime state like Great Britain. Of course, you know about it. And whenever you speak with an English lawyer, he usually say that, well, it's English law which is the law of the sea. Well, in a way, yes, but as you could see, there are many sources of the law of the sea in the history of its forming, which are really very important, and one of these sources is, of course, Rôle d'Oléron. The laws of Visby, or maritime laws of Gotland. You know where Gotland is? I hope it's in the Baltic Sea, and again, Great Britain has nothing to do with this island. Gotland is really a nice place, and the maritime laws of Gotland also influenced the development of the law of the sea. This is a collection of maritime laws consisting of 3 parts, including the addition of the rules of Oleron, extracts from the laws of Amsterdam, and the statutes of the Hanseatic city of Lübeck. The laws of Visby, developed in the 15th century by the merchants of Visby, were enforced in the trading cities of the Hanseatic League. They were published in Copenhagen in the 16th century. The maritime laws of Gotland are widely cited, and when we look at the contemporary sources, for instance, the statute of the International Tribunal on the Law of the Sea, and you might be surprised to see the reference to the Hanseatic culture, and also that Hamburg, where the International Tribunal for the Law of the Sea has its residence, Hamburg is considered as such a city with this culture. The laws of Hanstowns, it's a set of maritime laws that were created by the Hanseatic towns. The Hanseatic merchant marine was the most important for developing commerce in this region. And therefore, the League itself and its members took a special care to secure and increase their shipping at any cost, to regulate its relation to commerce and to prevent foreign competition. For example, if several ships are together on the same voyage, they are obliged to be liable to all the damages that may happen to the others by an enemy or pirates. Pirates, of course, it's a specific topic in the history of the law of the sea, because pirates existed from the time immemorial, it seems. Whenever states appear, whenever coastal states appear, whenever maritime commerce develop, of course, pirates are always there. Sometimes states support one group of pirates, other states support other pirates. Pirates sometimes have a sort of documents from this or that coastal states. States accuse each other that they help pirates, and pirates are the how do we call it? Враги рода человеческого. Well, it's difficult to translate in English, but in any case, pirates are an enemy of the world, mankind, and so of course the union between states, the agreements between states that they all be against pirates, it also has its own history. And another source, which is also not very, so to say, often noted in the textbook on the law of the sea, it's the Black Book of Admiralty. Probably in English textbooks, yes, it's mentioned, but in the textbook of, say, France or even the United States of America on the law of the sea, they just do not mention about this source. A collection of maritime laws of England, a compilation started under Edward III, you could see, the 14th century. It was written in ancient Norman and translated into English at the suggestions of Jenkins, who was in the service of Charles II in the 17th century. Many of the rules of the Black Book of the Admiralty were based on the customary norms, which were applied to English and foreign merchants and seafarers by self-governing coastal states. I hope everybody understands who are merchants, who are seafarers. Merchants, these are those who are on merchant vessels, and seafarers are those who make their living from fishing, from, say, whaling, and so on. So these are different, but the first and the second, of course, they are users of the sea, and of course, they are engaged in the maritime activity themselves. Some of the rules of the Black Book of the Admiralty were based on the rules of Oleron. At the end of the 18th century, the original text of the Black Book of Admiralty was lost. The text was restored from a surviving copy and published in 19th century only. So now we are coming to the last very important ancient source, which also had a great significance in the history of the law of the sea, Cod Del Mar, a set of local laws, customs, and usages that developed and operated in the coastal states, firstly in ports of the Mediterranean Sea coast. Again, I understand that the question might arise, we understand what is laws, we understand what are customs, but what about usages? Usages is a sort of a stage in forming customs. And sometimes for students we explain that how customs are formed. For instance, there are many, if you have to cross a forest, there might be this road, there might be that road or that road, and sometimes different people choose this or that road. But at the end, there is more and more people following this road, and that is why this usage is becoming a sort of general usage. And it is not yet obligatory. And that is why this usage differs from custom. Interesting enough that these are legal terminology, and in fact, if you mix custom and usage, of course, in the court or in your future work, it's not good. So I would advise you to understand the difference between usages and customs, of course. Cod Del Mar was compiled in Catalonia and was probably first published in Barcelona, so Spain, as you understand. While being just a compilation, the code is characterized by the absence of a unified style. According to some scholars, the code is a common product of the rule-making of a number of coastal states. Many of its provisions form the basis of the maritime legislation of European states. And that is really very important, because you understand that the maritime legislation of any coastal state is important for many states, not only for this particular state. For instance, you probably have heard that Canada has its own maritime legislation regarding the right to pass through the northern west, how do you call it? Северо-западный, northwest passage, yes, северо-западный проход. And Canadian national legislation qualify this particular area as internal waters of Canada. And of course, in order to pass through these internal waters, other states are legally obliged to follow Canadian national regulations. So for any state, of course, national laws are really very important. If, for instance, you do not observe this or that regulation, for instance, concerning the environmental issues, because, of course, every vessel has something to understand that if the environmental regulation of a coastal states, which regard the maritime security of a coastal state, of course, these are very important to follow, to observe. And if we say that maritime legislation of the European Union countries are more or less, I would say, similar, that is not the case with Canadian legislation. That is not the case with United States legislation. That is not the case with the Russian national maritime legislation, specifically about legislation regarding the marine environment in the Northern Sea route, or, for instance, security issues in the Northern Sea route. So it is the right of specific coastal states to adopt this or that maritime laws. But of course, the international law of the sea, its purpose, its mission in the world civilization is to harmonize this maritime legislation. Now we could see that the Cod Del Mar really formed the basis of the maritime legislation of many European states. And of course, it had a significant impact on the development of the law of the sea in general, including, by the way, the right of innocent passage. At the beginning of the lecture, I told you that this right is really very, very important for any state. On the one hand, we understand that states are interested to cross the territorial sea of another state freely without consent of a coastal state. On the other hand, the coastal state is interested that this innocent passage is done, is performed in accordance with the law of the sea. And the interpretation of what is the legal obligation so that this innocent passage is really innocent passage, this, of course, this interpretation is really different. For instance, this is one of the examples how history of the law of the sea links us with interpretation of the modern law of the sea. In particular, interpretation of UN Convention on the Law of the Sea. As I told you, the UN Convention of the Law of the Sea, and you perfectly probably know about it, is a sort of constitution of the world ocean, something like that. But the major idea is that this legal document is of universal character. More than 170 states participate in it, and so on. So I am finishing my lecture by showing you just one of the examples how different states interpret the innocent passage issue in different way. I'm basing my lecture on the incident which took place in 2020. So you could see here the far east of the Russian Federation. We have the internal waters. It's a Gulf, the Peter the Great, Залив Петра Великого, Peter the Great Gulf. And as you could see, these are internal waters, and this is Territorial Sea of the Russian Federation. As I told you before, the state boundary is here. That is, the outer limit of the Territorial Sea is a state boundary of any coastal state. So the U.S. naval vessel was approaching to the Territorial Sea of the Russian Federation. And as you could see, the Russian warship is also following this, because if, for instance, they crossed the Territorial Sea like this, yes, that might be no problem, because the innocent passage of the Territorial Sea is legally provided by the United Nations Convention on the Law of the Sea, like by Convention of 1958. But as you could see, the direction of the U.S. vessel was not to be, so to say, to pass through the Territorial Sea. If, for instance, it was like this, yes, it might be innocent passage. But as you could see, the direction of the American warship was to the internal waters of the Russian Federation. And internal waters have a different status in comparison to the Territorial Sea. Internal waters, the legal regime of internal waters does not provide for the innocent passage. And if, for instance, a warship is within internal waters without consent of a coastal state, that means a violation of international law. And since we say about the warship, of course, it's an act of aggression. And that is already reflected in a number of international law decisions, including, for instance, the Corfu case, when the military warships were engaged in this particular passage through international strait. In this particular case, since the US warship was warned by the Russian warship, the US warship decided not to follow to the internal waters of the Russian Federation and make a maneuver like this, and again was, so to say, out of the Territorial Sea. So the question arises whether this was an innocent passage or not. If it is an innocent passage, no problem at all. If, for instance, it is not an innocent passage, then the diplomatic protest might be prepared. It's a usual practice. If, for instance, we speak about internal waters of the United States, Chesapeake Bay, like this bay also. Chesapeake Bay is an internal waters of the United States of America. And of course, Russian warships do not come to the Chesapeake Bay. Here, a United States warship was maneuvering like this. And even in our country, we have discussion whether this action of a warship was a violation of international law of the sea, or not. So most of the legal experts decided that there was still violation of international law, though the warship has not come into the internal waters. Still there is a violation. Why? Because the UN Convention on the Law of the Sea provides some specific provisions what is not an innocent passage. And among these numerous provisions which are reflected in the United Nations Convention on the Law of the Sea is this, that the warship cannot make maneuvers in the Territorial Sea. And this is a maneuver. If, for instance, the warship goes like this, yes, this is an innocent passage. But in this particular case, maneuver means that this is not an innocent passage. In any case, we think that, of course, on the one hand, the law of the sea is very vivid, very, so to say, very modern issue. On the other hand, we see that the modern law of the sea is based, so to say, by the ancient sources, and sometimes, especially during the maritime disputes, sometimes when a court or arbitration tries to consider the dispute between two states, whether it's an innocent passage or not an innocent passage, whether a warship was granted immunity or not granted immunity, and so on and so forth. Again, we are obliged to look through the documents and interpret contemporary norms of international law, taking into account some ancient legal documents. Thanks a lot, and if you have questions, I'll be glad to answer. Yeah.
Professor, because you mentioned UN conferences and the Hague conference, what are the reasons that, for example, small coastal states have suggested that territorial sea should be, for example, 20 nautical miles, and greater states, they suggested, for example, 3 or 4 miles. What is the reason?
Yes, it's a legitimate, really legitimate for any state to suggest this or that breadth of the territorial sea. You mentioned about 12 miles, 20 miles, but I might say that there are cases when states adopted national legislation according to which the territorial sea is 200 miles. There are some states in Latin America. And of course, afterwards, after pressure from different states and after the conferences, the first UN conference on the law of the sea in 1958, they just skip aside their previous position and they decided to follow the general rule, the breadth of territorial sea not more than 12 miles. But initially, what was the reason? The reason is that when we look at the mighty naval powers like Great Britain, like United States of America, with all these warships and so on, avianosics, aircrafts and so on the wars. Of course, we understand that they are interested to control more high sea space. For them, the larger high seas area is the better. For small coastal states who do not have such mighty warships, of course, they are interested in the larger breadth of the territorial sea. It seems for them that if a foreign warship does not approach to their coast, say, nearer than 12 nautical miles, probably more, then is an advantage for them. So I would say that, of course, this is one reason which was probably predominant or prevailing in the early history of the law of the sea. But there is another reason, of economic one. The issue is about the natural resources of the coastal zones. And in fact, when there were only two legal regimes on the seas, high seas, where freedom of fishing, freedom of navigation, freedom of developing mineral resources, that is one picture. And on the territorial sea, all natural resources belong to the states. It is the coastal states which control the utilization of natural resources in the coastal state, in the coastal zone. So the breadth of this coastal zone, the more the better for a coastal state. I think that the compromise was developed during the third conference, UN conference on the law of the sea, because it is at this period of time that most of the states who participate in this conference, they decided to have not only the territorial sea and high seas, but to have also the exclusive economic zones. In fact, during the first conference on the law of the sea in 1958, there was already an institute of fishing zone. But again, these fishing zones were not more than 25 miles from the baselines from which the Territorial Sea is measured. And on the other hand, these special fishing, exclusive fishing rights were sort of a limited nature. When we say about exclusive economic zones, it covers not only fishery, but it covers other areas of economic activity, and among them, of course, the most important is exploitation of oil and gas resources, the bottom of the exclusive economic zone. Even if a coastal state does not adopt national maritime law regarding the exclusive economic zone, we have such situations. Still, according to international law, the continental shelf that extends from the bottom of the Territorial Sea, seaward, the continental shelf is also a domain of a coastal state. And the continental shelf extends up to 200 miles according to the UN Convention of the Law of the Sea. At least it might extend further beyond 200 nautical miles, but for these cases there should be specific circumstances which are again provided in the UN Convention on the Law of the Sea of 1982. Anyway, the general answer is yes. The initial idea for a coastal state was, of course, security. But today, the impetus for large area of sovereign rights, of course, are economic reasons. Fishing resources, mineral resources, and some other areas of economic activity.
Thank you.
My question will be about Selden's idea that all seas should be closed, that you mentioned at the very beginning of today's class. So if you could tell us more about that. And my second question...
No, excuse me, could you kindly reiterate your first question?
If you could tell us more about Selden's idea that all seas should be closed. And my second question, closely connected with the first one, will be, did in any way Selden's idea of mare clausum contribute in today's norms of international public law?
First, I would like to say that Selden was not for closing all seas. Selden was for authority, for state power, for the right, as far as international law concerned, for the right of Great Britain to regulate activity in all seas which are adjacent to the Great Britain. And as you understand, at that period of time, take into account, Great Britain was not as it is today. It was really a huge empire with overseas territories and so on and so forth. So it is really a huge territory and huge sea areas which are adjacent to the territory of Great Britain. So, of course, Selden, it's not just a lawyer who was so brave that he decided to dispute with Hugo Grotius and so on. No, of course he was acting on behalf of the King of Great Britain. And I think that his idea was to defend national interests of Great Britain at that period of time. Now, about what is the influence of this concept, mare clausum, for contemporary law of the sea. I think the compromise which is reached or was reached at the UN conferences on the law of the sea, beginning from the conference in 1958, I think this compromise was based on this battle of ideas between Hugo Grotius and Selden, because again, some states which are not coastal, for instance, for them, of course, the ideal picture might be there is always high seas area. In that case, as a state which is situated without sea coast, its vessels, for instance, through river, might reach to any coastal state. And for them, the total high seas, the world ocean as the only area of the high seas, might be attractive. On the other hand, for coastal states who are thinking about their security, who are thinking about economic interests, about their natural resources, marine natural resources, about conservation of these marine natural resources, about management of these marine natural resources, for them it is vitally important to conserve some area as closed for foreign exploitation of natural resources and so on and so forth. Even as in the case of Canada and in the case of Russian Federation, even for navigation, because Canada doesn't want that warships of foreign countries might enter the Northwest Passage without consent of Canada. The same with Russian Federation. Russian Federation does not want that warships from Great Britain or from any other country which have nuclear weapons on board might approach to its Siberian cities and on a regular basis using this freedom of navigation as a principle of the high seas. So I believe that the concept which have today internal waters, territorial sea under the sovereignty of a coastal state, and high seas area, which is where the freedom of navigation is applicable, and also the exclusive economic zones and continental shelf areas, where the relevant coastal states has right to exclusively exploit its natural resources. This picture is really a reasonable compromise, and it is based, I believe, on the results of this, as far as concepts are concerned, on the results of this struggle between mare clausum and mare liberum. Any more questions?
Well, if I could just briefly, first of all, thank you for the wonderful lecture, because you introduced all those medieval sources that we don't really know much about if someone's not deeply interested in this matter, and it was immensely interesting.
Thank you.
What I wanted to ask is, essentially, of course, in all these issues we see a practical conflict of interests. Not only was Selden defending the interests of Great Britain, Grotius was also defending Dutch interests. He may have been a genius and a great jurist, but essentially he was also defending his homeland as an emerging naval power. The same in the wonderful quote from Pyotr Ivanovich that you gave us writing to Elizabeth, that again his position is as the ruler of a country that has a large coastal zone, but that is not at that time a naval power comparable to England.
Yeah.
But do you know, maybe, is there someone who tried to develop a concept that was really purely theoretical and aiming for some common good, not focusing on the interest of an individual state, or are all compromise solutions just that compromises between representatives of states which have conflicting interests?
Well, usually Arvid Pardo, the author, as he is considered, of the common heritage of mankind concept, is usually referred as a person who tried to introduce a new concept for the law of the sea, this concept of common heritage of mankind. His idea is that since the continental shelf is already reserved for coastal states, but beyond the continental shelf is an area where there is no jurisdiction of any states, and since taking into account that there are already information about high value of mineral resources of this particular area of the bottom of the world ocean, probably we can invent some legal mechanism basing on this concept of common heritage of mankind, which provide some benefits for those states who do not have coasts, who are in a disadvantaged geographical position, and at the same time for the coastal states. The idea was to harmonize their interests, since the natural resources of this area, huge area, beyond the continental shelf areas, these resources are of great value. And at the period when the preparatory committee of the Third Conference on the Law of the Sea was convened, at that period, in fact, the estimations of the value of these natural resources, mineral resources beyond the national jurisdictions were really very, very optimistic, probably even optimistic. But in any case, I would say that this general concept was realized probably not in the best way in the UN Convention on the Law of the Sea. As you know, the first version of Part 11 of this convention, it was, I would say, formulated in such a way that there might be more benefits for the developing countries, for the landlocked countries, and so on and so forth. But as you know, after the convention was adopted, even it was signed, the large group of Western countries, USA including, decided not to ratify it. And in these circumstances, there was a sort of alternatives whether the convention might be applicable with this common heritage concept, but without Western countries. On the other hand, probably to insert some changes in the legal regime of the common heritage of mankind. and it was decided to take the second choice. And afterwards, in 1994, there was agreement reached on how to apply, interpret Part 11, part which is devoted to the area beyond national jurisdiction, to the legal regime of natural mineral resources of this area. And the agreement of 1994, of course, totally changed the legal regime which was provided initially. So, of course, it was a sort of cession in the interests of United States, Western countries, but that is also reality, because free market economy, which was, so to say, inserted in the agreement of 1994, is a reality. And so today we have more investments in the activity in this area. And as you know, some of the projects regarding the exploitation of mineral resources of the area are really working rather successfully. So I think that this concept probably influenced more than concept of Selden and Hugo Grossov's, and I think that in any case, I think that the concept of common heritage of mankind, concept of maritime, of common heritage of mankind will be developed, since there are very successful projects, probably not so successful. There are pluses and minuses regarding the agreement of 1994 in comparison to Part 11 of the UN Convention on the Law of the Sea. So this concept is also not static, it's dynamic, it's developing, and I think that today we are witnesses the reflection of this concept, common heritage of mankind, in the arrangements within the United Nations regarding the natural resources of the outer space. And we discussed it during our conference, because the Moon Agreement, for instance, of 1979 provides also for natural resources of celestial bodies are common heritage of mankind. But as you know, again, the United States are against this agreement. The United States didn't sign this agreement. The Soviet Union, by the way, also didn't sign it, though both the Soviet Union and the United States participated in discussion regarding this common heritage issue of as applicable to the natural resources of celestial bodies. So the concept is vivid, the concept is developing. Probably we might see that in the outer space law it will have different legal mechanism in the long run. Today there is no legal mechanism for the concept of common heritage of mankind applicable to the natural resources of celestial bodies. But there is mechanism for this concept applicable to the mineral resources of the area. beyond national jurisdiction, that is, to the seabed beyond continental shelves. Yes, if you are not tired yet, if you have any questions, please. Tired. Thank you so much. Thank you for your attention.